Welcome to the joint hearings being held by the House Judiciary and House Transportation Committees. Chairman Taylor and I, and Representative Ron Marcico, the Chair of the Judiciary Committee, are pleased to be able to convene our committee topic. Today's committee topic on the Pennsylvania's drunk and drugged driving. That's better? Is that better sound? Okay. So before we get started, I just want to give a big thank you to Mayor Kenny and the City of Philadelphia administration for having us here today and their hospitality. It's always good to be in the great city of Philadelphia. So I want to say that, so you all know, this is being recorded, as you can see, and then also, please, if you have cell phones, silence your cell phones. Before I make some other remarks, I'd like for the members of the committee and staff to do introductions. We'll start over here with Eric.
Representative Don Costa, 21st District, Allegheny County.
Representative Becky Corbin, 155th District in Chester County.
Kate Harper, I represent a portion of Montgomery County.
Tom Demick, Judiciary Executive Director.
Ed Nielsen, Philadelphia County.
Good morning, Maria Donatucci, Philadelphia and Delaware County.
Hi, I'm Perry Warren, Bucks County.
So like I said earlier, we're here to talk about Pennsylvania's drunk and drugged driving laws. There isn't any particular legislation that we're going to be focused on today, but rather the committees will be hearing testimony from various experts about what is happening in Pennsylvania right now regarding DUI and drug driving. We're joined by judges, judicial officers, retired judges, law enforcement, and others who are providing innovative treatments in this field. So we look forward to hearing from the testifiers on how Pennsylvania's criminal justice system handles these offenders, about changes in technology that are being put to use in DUI and drugged driving cases, and how the criminal justice system might be improved to handle these cases better in the future. With that, I'm going to turn it over to Chairman Taylor for some remarks.
Thank you, Ron. Good morning, everyone. I'm Representative John Taylor from Philadelphia and Chairman of the Transportation Committee. I just want to apologize for getting started a little late. This is a hearing that's part of a two-day number of events for 5 different committees that have come to Philadelphia to do a variety of things, both yesterday and today. So we apologize. We were just finished up a workforce development hearing downstairs and had breakfast with the mayor. I said to Judge Barace before we started that his testimony and testimony of others back about a year and a half ago about the enormity of this problem was some of the best testimony that this committee has ever received. And I think we are poised now not to only deal with legislation that will keep us up with what's going on out on the street, but it blends in well with a variety of things that we're poised to do in terms of just safety in general, distracted driving, use of radar, and the excessive speed on our roads. So we're looking forward to the testimony today, and I think this is really a perfect time to receive it and to put pen to paper going into our busy legislative season. I'd like to just now turn it over to my co-chairman, Representative Bill Keller.
Thank you, John. My name's Bill Keller. I'm the minority chair of the Transportation Committee. It's a good thing going last chairman to speak because everything good's been said, so I won't take up too much time. But I'd like to point out that this session, the public hearings we've been having have been very successful. John's been able to drive some legislation that's been very helpful for the whole Commonwealth. And I see from the list of testifiers, I think this one will also be very successful. and I'm sure we will be able to help get some good legislation out of this. Thank you, Mr. Chairman.
So we've been joined by Representative Stevens, Representative White, Representative Quartz, Representative Dawkins. We have scheduled sort of like 20-minute segments for each testifier. So and we have 5 testifiers scheduled for the testimony today. So if I can ask Honorable Michael Barrace, President and Judge, Lackawanna County Court of Common Pleas, please come forward. Morning, Judge. It's good to see you again.
Good morning.
When you're ready.
Good morning, and thank you for this opportunity. For everyone here today, I'm going to actually, I don't want to be redundant in some of my past testimony before you, so I'm going to shorten it a little bit, really to make opportunity for questions, because I believe that questions and the answers that go with it are more probative than what I may see as being the problem. I thank you for the opportunity to address this panel regarding the ever-increasing wave of drug driving. There are no coincidences that other panels, both in the Senate and House, are addressing at the same time the deadly heroin epidemic, as well as issues surrounding medical marijuana. There is a direct correlation between the deadly, predictable epidemic and this issue. First, let me share with the panel of my background from where I speak. I presently serve as the chairman of the National Drug Courts. I'm also the chairman of the State DUI Oversight Committee, looking at cases that go through the judicial process and the failures in regard to some of the treatment and some of the other aspects surrounding it. And I also serve PennDOT as the Pennsylvania Judicial Outreach. I was formerly the DA for 3 terms in Lackawanna County and had the privilege of working in this building as an assistant DA for a number of years. While the issue of drug driving may seem as an emergent issue, it is not a new one, nor is it one that cannot be prevented. However, in all my years as DA and judge, I've never seen this tragic, widespread, and deadly. There are several issues that I believe are being worked on by Department of Drug and Alcohol, as well as PennDOT and the state legislature regarding prescription abuse and now medical marijuana. As I am sure each one of you are aware, while the United States has approximately 4% of the world's population, over 80% of all the opioid use is here in the U.S. However, the studies of drivers under the influence of marijuana is a more recent and less studied problem. A recent survey that came out yesterday from the National Center of State Courts reports a Colorado study that shows that more young adults, 2 years out of school and older, are driving with people under the influence of marijuana rather than alcohol. Obviously, from our past, it's a huge change in regard to what people are driving, under what influence they're driving. Since 1980, MAD helped lift public awareness to the dangers of DUI, and that was viewed as an alcohol-only related problem. It was not even until 2015 that even MAD changed its mission statement to include help fight drug driving. In fact, here in Pennsylvania, the 2015 PA Crash Fact and Statistics looking at fatal crashes in Pennsylvania looked at alcohol-related, but has no mention whatsoever of drug driving or polyuse, the combination of drug and alcohol. Yet PennDOT and AOPC data clearly shows the rapid increase in DUID, meaning driving under the influence of drugs. The reality is that the presence of drug, illegal or legal, is more prevalent than the finding of only alcohol. While it may be understudied in academia and science, unfortunately has been well established in courtrooms and cemeteries across this Commonwealth. It is well established that the victim and the families of those killed that drug driving is no different than drunk driving, and that the criminal justice system and the legislature need to do more. I am sure each one of you are aware of the statewide numbers for arrest and conviction. I'm not going to go through all of them, except to say that there's a dramatic increase. As you've been made aware, law enforcement can inexpensively test for individuals' BAC determine the amount of alcohol in the individual's system and the presumptive level of impaired driving. That is not as easily done for drugs. Compounding the present problem, some counties and agencies, once they find that sufficient alcohol is present to prosecute, never bother to see if drugs are on board. Other counties have policies in place to detect if drugs are in the person's system if the BAC is a low tier. Counties like York, and here today you have present the judge who was really responsible for probably the best program, not only in Pennsylvania, but the country, and that's Judge Jack Kennedy, and Lancaster have absolutely seen a doubling in the number of drug driving cases over the last 6 years as a result of their proactive efforts to detect drugs. In neighboring Montgomery County, they have seen an increase in drug driving convictions while DUI convictions remain the same. The number of alcohol-related convictions over these years have decreased. The number of DUI have remained constant, but that DUI is now the drug driving. In my county of Lackawanna, while the arrest and conviction numbers are similar to those I just mentioned, there is also another shocking statistic, which is in the last 4 years, while 17 people have died in a substance abuse death crash, 16 of those deaths involved either drugs or drugs and alcohol. Only one of them was alcohol-only related. Recently in our county, a defendant pled guilty to homicide by motor vehicle for the death of a passenger in their car on Route 81 under Xanax and heroin. The following week, a 30-year-old woman was sentenced for 3 DUI drug driving over a 6-month period. And that's going to get to a second part, and I know that Judge Kennedy is going to talk about the efforts that he and York County made in regard to addressing the people that have been arrested in a second and third time before their first conviction is ever completed. This woman's third DUI while driving under prescribed Xanax and Percocet, she struck a crossing guard and a young student who suffered contusions and brain bleeds and broke 2 arms. The blood draw on the defendant showed not only the Xanax was in a toxic level, the pill count indicated that she should have had 168 pills and only had 30 at the time. We see the destruction. The question is, where do we go? This legislature has passed per se laws dealing with those individuals who have illegal substances while driving. For those drugs, as well as the legal prescriptions, the courts have to ensure that law enforcement has probable cause to detain and arrest these individuals. The officers need sufficient training and testing equipment so that the arrest will survive the court challenges. To this end, the individual police departments often say they lack the funding to send their officers for the requisite DRE training, especially in regard to the salaries for those officers that are missing on the street in their own towns. There must be adequate funding for these programs if the qualified individuals are to testify. The courts cannot blindly accept testimony without adequate training. As was mentioned earlier, testing for BAC is not difficult or expensive. The same does not hold true for testing of drugs. If the Commonwealth plans to seriously address this issue, drug driving, then adequate procedures and funding for chemical testing must be complete. As you're aware, the Supreme Court recently ruled in Birchfield that it cannot increase criminal penalties in regard to those individuals refusing to test or to be tested. Law enforcement needs greater legislation in regard to the issuing of search warrants that deemed necessary for the courts. The issue of arrest, though, in due process is a primary issue. And what I really would like to talk just a minute about today is the second one, what occurs after a conviction. If adequate treatment level of care is not mandated for those convicted of drug driving, law enforcement efforts will be futile, catch and release results. The arrest and conviction should serve as a therapeutic intervention to ensure that these individuals receive the proper drug and alcohol treatment they need to ensure they are not back behind the wheel of a car drugged driving. We cannot imprison our way out of this problem. Besides arming law enforcement with the tools they need, we need to ensure that the proper level of care treatment is mandated on these individuals. DUI courts and drug courts have proved to be effective tools in reducing recidivism. We need to make sure that the DUI courts and the drug courts are the systems that are supplied, with the resources they need so that recidivism is reduced. Whatever measures the legislature looks to do combating drug driving, DUI and drug courts, with an emphasis on treatment and a defender being held accountable for their treatment, must be addressed if you truly intend to stop these preventable tragedies. I want to thank you for your time, and I really am open to any questions you may have.
Thanks, Judge. Before we go to questions, I want to recognize Representative Briggs, Representative Knowles, and Representative English, who have also joined us. Questions or comments? Representative Harper?
Thank you for your testimony, Judge. From your vantage point, do you see a conflict between better enforcement of drug driving laws and the move to decriminalize small amounts of, say, marijuana and things like that? Is there a conflict there?
I really don't see a conflict for two reasons. Alcohol by itself is legal. Medical marijuana in of itself is legal. Xanax and other medications are illegal. The question is the use and driving. And then the other part, obviously, is a substance use disorder. If the person has that substance use disorder and it's not being treated and they're driving and they're not being accountable for their actions, that's where I think the conflict comes in for the courts in regard to saying, what is our role? You know, there's four reasons for sentencing. You know, one is punitive, just to take it out. The second is to make sure a person's incapacitated. And the other is, in regard to DUI, has always been to deter both that individual and others. But the fourth has been rehabilitation, and it's not been worked on. So the conflict that the court that often has is we see mandated sentencing. We see sentencing guidelines that basically say, what is the prior record score? What is the offense gravity score of this? Look, see what the mandatory time is, and we never look at the individual and the underlying problems. And so that's where the conflict really comes in for the courts. The arrest, I often look at the arrest as a healthy time. Arrest means stop, to intervene in that person's substance use disorder and to protect the people on the streets. And that's really what we as a court need to be looking at, not what's done beforehand.
Thank you very much.
Representative Nielsen?
Thank you, Mr. Chairman. Thank you, Judge. Judge, you brought up an interesting point in your testimony about someone who had only 30 pills left of their prescription. A lot of times at our offices, we have people that have to turn in their license and surrender their licenses because maybe they had a seizure or for other reasons. I just wanted to get your thoughts on, is that something we should look at as a committee or as a legislator? Say, hey, look, if you're getting prescribed 100 pills, you need to surrender your license, your driving privilege, and it's a whole. Because if not, maybe you limit it, hey, this is 1 week prescription, you have to go back to the next week. I just wanted to try and get your thoughts on the record, Judge, because we're trying to help a situation here, and we're
I think
taking
that
all
is a
kinds of
very,
approach.
to be quite frank with you, I believe that that's a very difficult balancing act for the legislation to do for several reasons. One is it may be a person is going to be on oxycodone or Percocets for a couple days coming out of the hospital. Is that going to be one in which, first of all, as a practical matter, how is that going to be facilitated in regard to taking of the license? As we know in all the studies, 82% of the individuals that lose their licenses drive anyway. So yes, I believe that the type of population that we're looking at in regard to prescription drugs, I believe, is a different population. It's not your normal criminal element that you see in other type of cases. Many of those individuals, the first time a policeman pulls them over is the last time they're either going to use drugs or alcohol and drive. For that population, yes, having some mechanism in place would be productive. For the others, the vast majority of them, however, they're going to drive anyway. Do I believe it's one tool? Yes. But in regard to taking licenses, I would like to just put one footnote. I truly believe that it is a very ill-thought process to just say we're going to take someone's license, and especially for the draconian times that we have in our present law, when the reality is many of these people, for example, in DUI court, whether it's Judge Kennedy's, which is below 4%, or my court, which is below 6%, these people, we're asking them to make sure that they're working, make sure they're being a parent, make sure that they're doing all their obligations in regard to the court, including probation, including treatment, and oh, by the way, give me your license. In Philadelphia, you might be able to get away with that because of the transportation system. You go to a lot of rural Pennsylvania, these people are now, the reality is, they're driving without a license. So they're uninsured, you have many problems that come along with that, and once it happens, the financial terror it does to a family is very destructive. I think we need to look at provisions that enable people to get their license back, not just look at what we need to do to take them. And why I say that is mandatory sentences have not always proven successful if it's not coupled with rehabilitation. Same thing, too, with taking someone's license. If you truly want to see somebody be productive again, and the purpose of sentencing is change behavior. It's not just to punish a person. If a person rapes somebody, yes, it's punishment. But if a person is drunk driving, what you're really hoping for is change behavior because of the fact that they're in the criminal justice system. By having them in it, have them do all the things they're supposed to do, and then say, give me your license, is not productive. So I don't believe that licensure is necessarily the way to go.
Thank you, Judge. Thank you, Chairman.
Chairman Taylor?
Judge, I just want to get your reaction, as well as maybe Judge Kennedy's reaction, to the relationship between the legislature and the courts. And we have this on a number of fronts where there's legislation proposed.
We're not talking about election matters, are we?
No, sir.
Okay.
No. Well, you know, it's another example, though. But there's legislation proposed to mandate certain activities by the court, for example. And you had talked about the success of your drug court. But for us to mandate that, I mean, the courts can do it on their own, may or may not feel that we have the ability to tell them what to do anyway. Has there been more progression towards these courts
We have seen,
statewide?
over the last 10 years, Chairman, we have seen a huge increase in regard to it. And no, the court does not believe that legislature has the ability to mandate what the judge actually does in the courtroom in regard to it. However, the belief of many of the judges has changed. If you were talking to judges 10, 15 years ago about problem-solving courts, they said, wait a second, that's not our job. Our job is to call balls and strikes. It's not to go ahead and be social workers. Because of the statistical information that's come out of the National Center of State Courts, the National Judicial College, and the Department of Justice showing the lowering of recidivism, more judges have bought into the program. There are many areas that have practical reasons why they can't do it. You have a one-judge county. Trying to take away the judicial resources in regard to doing problem-solving courts is a problem. But the second part is there's also a financial upfront in regard to probation departments, more testing in regard to it. I believe that what we really need to look at is for the courts to have the resources, as has happened in the past, for example, through the Department of Corrections, where they have carved out part of that money and have put it into restorative intermediate punishment programs that have been very effective. I think it's the offering of those, and for the, especially for when you're talking about this population, a DUI and drugged population, you're looking at a 1 to 5 year. That person otherwise has a family. You look at the socioeconomic backgrounds of these individuals. You also look at other crimes that they may have been involved with. It may only be DUI. So the question is, if you offer those counties the capability of keeping that person here with their family and being productive, but yet also being accountable, I believe every judge and every county will participate.
Representative Stevens?
Thank you, Mr. Chairman. Thank you, Judge, for your testimony. And I share some of your concerns. I think, as it relates to driver's licenses, we can use more technology, interlocks, and other again, more modern technology to maybe help effectuate safer driving, but allow people to get to and from work and things like that. My question, though, you referenced changes to search warrant requirements in terms of enforcement. And I wondered, not to put you on the spot, but I wondered if you had any specifics there, or maybe if you didn't, if you wanted to.
Well, I know I believe your Judiciary has already looked at some of the issues surrounding the warrants at night in regard to different ways in which they could be effectuated through technology to make sure that the warrants can be gotten simultaneously. There's many states that have put enabling legislation in place that allows for electronic search warrants, and in the field of DUI, it's especially critical. And I think that I know you have many of the sample ones there, and I think it is something that you should be looking at.
Okay, thank you very much.
So, any other questions here? I want to recognize Representative Doyle Heffley. Do you have a question?
Thank you, Mr. Chairman. Talking a little bit earlier about getting a DUI, losing your license. Coming from Carbon County, a very rural county, we don't have mass transit. If you lose your license, you can't get to work, you can't do anything. And we did work on some legislation with the ignition interlock, be able to get that, the first-time offenders get it into the vehicle. However, and I support that, and I see people struggle, that maybe they they have a personal issue, and they go out for a couple days and they just have a bad time, wind up getting arrested, lose their license, and now they're losing their job. Two-part, I would like to see, the ignition interlock or maybe like a work license. However, how much of a deterrent is it? I know for a lot of people, we've really significantly reduced DUI deaths and accidents, and losing your license is a huge deterrent to a lot of people to want to drink and drive. So as we go through that, I think we want to keep the deterrence, but at the same time look at ways that we can get, make sure that people can still have their job. So do you think that losing your license is still a big deterrent in keeping a lot of people from drinking and driving?
Representative, I think you make a very good point. And I often look at this as being like a bell curve. So you have the people that even the thought that they're going to lose their license is going to prevent them from doing something. That's the low side over here. You see the ones the first time they see the police lights in their mirror as you're going up that bell curve, they're not going to drive again. Then you have the others that suffer from substance abuse disorder. They don't necessarily weigh before they get behind that wheel necessarily whether or not they're going to lose their license. And then you get the others at the far end, they could care less, they're going to do whatever they want to do anyway. But I believe that there is the necessity of having some type of accountability in regard to license and suspended, whether it be the ability to have it through interlock, or if a person is in a DUI court program, that they have a license through that court. Has proven in other states to be Michigan has studies on it, other states have many studies to show that the use of a limited license is an effective deterrent as taking away the license overall.
Recognize Representative McClinton, member of the committee, and also Representative Benninghoff, policy chair. Chairman Keller.
Thank you, Mr. Chairman. Unfortunately, my executive director is not next to me. I usually ask her these questions, but I'm sure you'll know, Judge. We're talking about losing your license and license suspension, and how difficult and the repercussions of that. But I was wondering, a person has a CDL and they're caught drunk driving. Do they lose their
license is gone
immediately?
And when you look at that's a very, very difficult question, because now you're looking at somebody that drives for a living, and they drive basically a couple ton, weapon almost. So on one hand, you're saying, this person's a danger on the road. On the other hand, you're saying you're taking away this person's livelihood, really for good in many circumstances. The other dangerous thing I see often throughout the state is that often DAs and courts, in smaller counties especially, know these individuals and know that they're going to lose their license, and they often then will have a plea to a lesser offense, meaning that the individual is not convicted of DUI. The problem with that and the fear of that is now you're not going to address the underlying problem of a substance use disorder if it's there. But again, measuring the fact that this person otherwise has nothing else in their criminal past, to see them lose their livelihood and to place the family in jeopardy to that degree, I think there has to be alternatives.
Well, I ask because I wonder if there's a statistic that shows that if you have a CDL and because of that severe penalty you have, is there a reduction in DUIs, DUIDs?
In that population, I don't know that answer. I mean, I'm making that up.
Well, we do that a lot too. If you Okay, thank you, Mr. Chairman.
Any other questions? Representative English.
Thank you, Mr. Chair. Thank you, Your Honor. As you talked about changing behaviors and underage drinking and ramifications, should we also be thinking about looking a little lower, people that are developing a pattern, underage drinking? You know, lots of times local magistrates may encounter, you know, there's it's just a student experimenting for the first time with alcohol, but then it's the second and the third, and there's a pattern, but they're let off because they're a good kid, or they're on the football team, or they're doing this, but they're really developing a pattern before they even get behind the wheel or the opportunity to get behind the wheel. Should we be looking at that as sort of some preliminary help for those individuals, and maybe that looks into stepping down into the magisterial district judges to us to say, gee, if there's a pattern developing, do we need to reach out and try to come up with something to help them at this time, even though they're not behind the wheel yet? Because we had a tragic case in our area where a young man had been 3 underage drinkings, never driving, but then once he had his driver's license, had a clean history, and on one particular day, downed, according to his testimony, about 18 beers and smoked some weed, and then went tearing through a neighborhood, a 25-mile-an-hour neighborhood. And then he literally tore from the mother's hands a young daughter, and then she died. So, but there's no record. It was an underage drinker. So how do we help changing that behavioral pattern that maybe the MDJs, using their discretion, maybe need to be stronger in exercising that discretion?
Representative, I think the easy answer would be yes. But the reality is that what you just mentioned, that's discretion. As myself and Judge Kennedy were talking about, lamenting earlier, one of the most difficult parts of being a judge is often sitting in on juvenile court. And because often who you really want to put behind bars is the parent, not the child. Also determining whether or not a young adult is in fact substance use dependent or an alcoholic, obviously it's much, much different. So the answer is yes. Should there be programs in place and not just be punitive and again, take license and everything else, but to say what needs to be done on both education and counseling and to be offered through a magisterial system that offers a program of diversion. That's allowed by the state legislature. Again, it would need an awful lot of discretion because it's a very, very difficult prognosis and diagnosis to make at that time.
Thank you.
Representative White.
Thank you, Judge, for being here today. Some of the issue that my staff has come across in the past with regard to DUIs is that a lot of folks, they come into our office a few years after they think that they've served their sentence or the 2-year time window, and hearing the fact that they didn't is shocking to them because they didn't realize that, they never sent in their license or, what is that time frame, that window between when they get their decision and then the time frame that they're supposed to submit their license to PennDOT?
That is all really up to the county and the way it's done, and the way the clerk of courts and the way in which the license is taken. Some mandate right from the beginning and make it part of their pretrial, which there's not actually a law for it, but it's a way in which they are accepted into an ARD program or a similar diversion program. The problem that you're talking about is not one that is, I think, a small number. Many, I think, are not doing what they really need to do to make sure that their license A is turned in so that they can get it back. Others, however, has been a real glitch in regard to a licensing at PennDOT.
Do you think that there should be a time frame, or do you think that as soon as that decision is made in court that they should just have to hand in their license immediately? Because, that's a major concern for, other
I think
people in the
Judge
street.
Kennedy,
Yeah.
who's going to finish up, is going to be able to show why it's so important that after a person is arrested and you're able to show prima facie that a person was under the influence, that license is a privilege. It's an administrative matter. It's different from the actual conviction in regard to what's happening. So I believe that administrative steps to take that person's license away, especially if they're not in a treatment program, is something that should be seriously considered by the state legislature on the front end. It doesn't help taking the person's license. Just think about this for a moment. Person's arrested for DUI. They do their time, they do their treatment, and then the license is taken at time of sentencing. That person has already gone through their treatment. They've made the changes they need to make. In the meantime, beforehand, when they weren't receiving their treatment, they still had their license. It's really illogical, and it's really makes our streets very unsafe.
I think that's what I was trying to get at. All right, so thank you very much.
Thank you.
Questions?
I thank you for your
Questions?
time.
Well, thank you, Judge, for your time and your testimony. We're very grateful for that.
Thank you.
Our next testifier is Mary Smithson, the Bucks County Clerk of Courts. Morning.
Good morning.
You may begin.
Good morning, everyone. Good morning. Good morning, members of the committee and distinguished guests that are present here today. My name is Mary Smithson, and I am the Clerk of the Courts of the Court of Common Pleas of Bucks County, Pennsylvania. And in my role as an elected official, I'm responsible for all the criminal matters associated with this hearing today on DUI matters. I was also formerly the president of State Association of Clerk of Courts and Pathonatories. I would like to begin by informing you of the background of our county. With a population of over 620,000 residents in our county, we have in excess of over 8,000 criminal cases on an annual basis. Prior to a DUI offender coming to our courts, the individual has to be processed through the district magisterial courts. Bucks County has 18 courts, and the average case filings of DUIs for the last years are as follows. In 2016, 2,131 cases were filed, and in 2017, 2,369 were filed and forwarded to the Court of Common Pleas. In the magistrative district courts, where the cases begin, each individual is provided with specific information directing him and her to arrange within 72 hours for a court reporting network, as we refer to as the CRIN evaluation. 3 agencies are approved by the county for this procedure. This includes the Council of Southeastern Pennsylvania, Live and Grin Foundation, and the Family Service Association. This evaluation will determine whether treatment or education programs should be ordered. The cost, which you should be aware of, including in the CRIN evaluation, is $65. Alcohol and other drug assessment, as we refer to as AOD assessment, is $140. Alcohol highway safety is $225, as this includes 5 or 12 sessions that the individual will participate. The blood alcohol content and the number of prior offenses of the offender is the barometer which defines the sentence which the judge would impose. I have attached in my testimony the penalties which apply to first-time offenders, second offense, third offenses, and subsequent offenses. This would include license suspension, 1 year or more, interlock ignition, which cost over $1,000, house arrest, court supervision, incarceration, and extensive fines. An average court cost for a DUI is over $2,000, not including fines, state and county, local municipal costs, of course, are also attached for your review at the end of my remarks. Just to be crystal clear, on an average, our collection of fees, restitution, and fines is over $500,000. The state receives monthly payments of over $236,000. Last week, with over 100 DUI ARD, first-time offenders cases, coming before the Court of Common Pleas, they are represented by public defenders and also private counsel. We collected that day $75,000. It is interesting to note that many of the individuals who have been convicted of a DUI are represented by private counsel. Their rates do vary, and I have indicated that between $2,000 and $5,000. Last year, in 2017, Living Grin Foundation reported a total of 821 evaluations. They indicated that the highest arrest rate was made on Sunday between the hours of midnight and 4 a.m. Those evaluations included a higher blood alcohol and drug-related substance. Antidepressants and marijuana were listed as the highest percentage as compared to cocaine. According to the Administrative Office of the Pennsylvania Courts of Convicted Defendants statewide, driving under the influence accounts for 17% of the total cases. As the custodian of criminal records, legislations which you have passed over the many years, and advertisements on highways, along with the support and guidance, for instance, of Mothers Against Drug Driving, major impact of awareness towards reducing the number of cases have been brought before the courts. Even Uber has changed our society today in really a meaningful way. The majority of citizens have mobile apps, and it's used effectively, thus reducing the number of DUIs. My message to you is very simple. The public has been awakened by the communication of existing laws. The costs are significant, the penalties are tough. This has reduced and decreased DUI arrest. There is no additional added legislation at this time, but for me, continuing with education is probably the key in the reduction of the number of DUIs. Thank you.
Thank you. Any questions or comments? Chairman Taylor.
Thank you, Mary. Was it anybody else? Oh, okay. Well, go ahead, Martin. Whoever was going to go next.
Okay, thank you for being here today. The last statement that you made with regard to education, I know that there have been numerous, you see the signs on the side of the road, no, DUI free, or, don't drive drunk, $10,000 fine, you can't afford it. What more can the state do, can the local municipalities do to better educate folks out there about what the penalties are or what you feel should be best told to them?
I would suggest two things. One particular is those who are applying for their driver's license. More education for them on that level is really very, very critical. Because, no matter the age, and it's not always just our young students at 16 that are applying and 17 are applying. There are older individuals that are applying. And that really is a key element from PennDOT to be able to have more instructions for them prior to them receiving their license. That really, truly does make a difference. There is no question that when you see those signs, people do think, and they, I would say to you, years back, they didn't think. But today, we find that individuals really do think first prior to getting into that driver vehicle. And I think that that's really important. But more education is really very, very important, again, with PennDOT, bringing it to the public. I would also like to answer your question that you had for the judge in regard to driver's license I will tell you that in our courts, if individuals want to give their driver's license to us that day, we take their driver's license. After they get a letter from PennDOT asking them to submit their driver's license, and they have it's usually about 2 weeks that they receive a letter from PennDOT telling them that they must submit their driver's license, and they do. One of the problems that happens in between that time is that when they have completed their classes and things of that nature, they've totally forgotten the entire issue, or whether or not they should have given their letter to PennDOT. And in the meantime, just so you know, they have moved. So their mail isn't forwarded. One of the things they're required to do is to notify the clerk of courts when they have moved. I will tell you, they don't. So that really is a reason we receive calls in our office almost the same as you do in your representative offices. I didn't know I had to do this. Nobody told me about it. That's not fair. My lawyer said that wasn't right. But there is a question that they have to be responsible. Okay. You're welcome.
Any other questions? Representative Donatucci.
Thank you, Mr. Chairman, and thank you for being here today. I'm curious about the ARD program. And I'm asking because I just received a letter regarding somebody who's going to have a ARD hearing.
Yes.
For possession of marijuana. I was rear-ended by this person back in November. Is that when this happened? Or would she have gotten a possession at some other time and they write to me? It was really strange getting this letter. I just recognized the name, so I knew who it was.
Right. I'm not sure where the letter came from that you were notified on it.
It came from the Bucks County, I guess the court system?
Yes.
Saying that I did not have to attend the hearing, that she was having a hearing, but that, I may be a victim and...
Right, exactly.
And it goes on the whole thing.
The issue for us here, and particularly in the county of Bucks, is that in regard to any type of offense such as this, since your name is, you are a victim, in that you would be notified that the case is moving forward in it and when the date of the case is set. Again, we just want to make sure that the victim knows because of that case that you were. Surprising.
But yeah, because I was very surprised, because I don't know if that happened that day. I had no knowledge of it if it did.
Right. Sometimes the other thing too is when it comes to court, the incident sometimes will take maybe 6 months before, and maybe even longer. It just depends on how it goes through the magistrative district court before it comes to the Court of Common Pleas.
Okay. Can you tell me how that program works?
Yes, I'd be happy to tell you. Individuals who the courts, and I should say the district attorney's office, have noted that the individual has, whether or not it was a small amount of marijuana or that the drug, the alcohol that they had taken was below as a first-time offender, and that's generally what it is for the first-time offender. A first-time offender has an opportunity to come before the courts to admit that has happened to them, and they have two choices. They can either, in Bucks County, I'll just speak for ourselves, if they pay their court costs and fines within 6 months, their license or their whole record is eliminated. So that what we do is we take that record and expunge it so that no one sees that record. And it is really very, very important, particularly now in today's society, for employment. Individuals now, companies now look to see if they have any type of criminal matters, and they won't hire them. I mean, it's very plain and simple. So the court costs that I had mentioned to you, I brought that in front of everybody. So those individuals must pay those court costs up front. Once they're paid and within the 6 months, then they're able to have their records expunged. We also do it if they are unable to pay within the first 6 months. Within 6 months, on that day of court, they have an additional 6 months to pay. So it's within 1 year that we will expunge the record and get them back to society. You're welcome.
Representative McClinton?
Thank you, Mr. Chairman, and thank you for your testimony. I appreciate you being so straightforward about how it's affecting Bucks County specifically and what it's comparing to statewide. I was a public defender here in Philly for many years, and DUIs were the most difficult clients, and not because some of them were actually struggling with alcoholism, but many people didn't see the crime aspect in the charge. They thought, oh, there wasn't an accident, it wasn't the worst case scenario, so what do you mean I have to lose my license or have to have it suspended? And in one particular incident, not someone I was representing, but a neighbor struggled with alcoholism for years and has literally lost everything because of the last amount of suspension and a period of incarceration. You stated that we don't need new laws because the laws are sufficient. I'm curious to know what type of education you think PennDOT should be doing specifically for new drivers, younger people, or even adults who just are getting their license for the first time and don't realize how easily it is to drive and be impaired.
Okay. That's an excellent question, and I go back to our Pennsylvania Department of Transportation. When there should be more YouTube videos and in regard to the examination that they're taking and the questions that are asked, that's really should be part of that before when they're making their application just for a driver's license. It is critical because what happens is they're not studying. That's not part of the study program for them. PennDOT needs to do better. And can they do better? I believe they can. I think that the new apps, as we say, that are every mobile device has one, that you can put another new app on your phone, should be there for individuals so that they can become more educated, more responsible, and more productive. And I think that's really what we all here in this room want to see happen. You're welcome.
Representative Quartz?
Thank you, Mr. Chairman, and thank you, Ms. Smithson, for your testimony today. Two questions. Number one, you mentioned that the DUI cases, 2369 last year. Would you have that broken down for the committee where the teenagers through 30, how many cases, and then 31 and above? Do you see the trend toward more younger people, I guess is where I'm going with this?
I don't have that statistic for you, but I must say to you from the numbers that I see that come in we have DUI courts twice a month. I would say to you the majority are over 30.
Or over 30?
Over 30.
Okay. My next question, real quick, if I may, Mr. Chairman. Back in Allegheny County, in my school districts, driver's ed has gone by the wayside. In your opinion, do you think it would be helpful if we would do something in the schools again for driver's ed and teach some of these young folks the practical stuff like stop at a red light, stop for a stop sign completely, don't drink and drive? Do you think that would be helpful if we would put some of these practical courses back in the schools?
Practical courses in high school are important. I can remember the DARE program, for example, as one that was really took off and was really very, very effective. And then it went downhill. And then we're bringing it up again. But the educational portion for all of the school students really will make a difference. And I believe, and I would totally support that.
Thank you.
It's
Thank you,
excellent.
Mr. Chairman.
Questions or comments? Well, thank you very much, Mary. Appreciate your testimony and being here. So our next testifiers are the Honorable John S. Kennedy, retired common pleas judge, York County, and Tom Van Houten, Director of Sales of East Alcohol Monitoring Systems. Welcome, gentlemen.
Good morning.
Morning, Judge. I just want to say that welcome back. It was in 2014. In fact, I have your testimony here from that hearing or information meeting that you came before the House Judiciary and Transportation Committees.
I see some familiar faces, and I've worked with Mr. Dimmick, or tried to work with Mr. Dimmick on various things throughout my career. I will say, you know, if you ever want a perspective on these issues, you know, Mike Barrace is a nationally renowned expert in these areas. I consider him to be one of my mentors, even though he came on the bench a little bit after me. I'm one of 7 regional judicial outreach liaisons for the National Highway Traffic Safety Administration. So both Mike and I get a perspective of these issues, not just in Pennsylvania, but across the nation. We've seen programs that work in various parts of the country. It is a significant issue, driving under the influence. I can tell you in Pennsylvania, most jurisdictions, most counties will tell you about a third of their criminal caseload are driving under the influence cases. And the unique thing about driving under the influence, in reference to Ms. McClinton's question, what I've found, and I've handled mental health treatment courts, I've handled drug treatment courts, I've handled DUI treatment courts, I've handled veterans treatment courts. In the DUI treatment court, particularly when you get your hardcore alcoholic, the attitude is, I don't have a problem, you got a problem with my drinking. Frankly, with the heroin addict and some of the other addicts, it's, I got a problem, I may not always want the help, but they'll at least admit they have a problem. The other thing about DUI that I think you have to put in perspective is, number one, in this country, if you're going to be killed by a stranger, it's probably going to be by a drunk driver. And the other thing about DUI is it's the one crime that you really can't protect yourself against. You know, if you're concerned about burglaries, robberies, et cetera, there are things you can do for your personal safety. DUI tonight at 4:30 to 6:30, 7:30, you're driving home. There isn't anything you can do to keep that drunk driver from coming across the road and killing you. Now, in Pennsylvania, you can pat yourselves on the back a little bit. We are one of 4 states in the country who had a decrease in highway deaths last year. Most of the other states in the country are seeing increases. But what I really want to talk to you about today is the process of what I call catch and release. Mike talked about that a little bit with the rehabilitation process. But he also mentioned to you about the woman in his jurisdiction who had 3 DUIs, relatively short period of time, and our third one resulted in fatalities. We noticed that same issue in Pennsylvania and in York County. And it's not just a Pennsylvania issue. It happens across the country. Statistics show that an individual, a repeat offender particularly, who's been arrested for a DUI, let's say January 1, and doesn't get to court until April, statistics show nationwide that about 25% of those folks will get caught again. And when I say caught again, that's because they drive many, many times before they actually get caught. And to give you a little idea as to why, I think Mike would agree with me. Most of our repeat DUI offenders, what we see, we generally 50 to 60% of a combination of drugs and alcohol, but we see BACs that are far above the 0.16 limit. You know, we see BACs generally in the 2s, sometimes the 3s. I've seen them as high as 0.54. Gentleman, Mr. English, raised the issue about the young man, 19, with several public drunkenness cases. I had a young man before me, 19 years old, 0.396. It was his first DUI. 3 previous public drunkenness cases. And because of Pennsylvania state law, which says that a first offense DUI is only punishable by 6 months, I really couldn't do any effective treatment. You need to have jurisdiction over someone for at least 2 years to have effective treatment. And as we all know, the criteria in the state to get to that third tier is 0.16. I don't think most people realize how drunk you are at 0.16. For me to get to a 0.16, I have to drink a fifth of liquor in 4 hours. I can't do that. Most social drinkers could not do that. So that's how intoxicated somebody is at 0.16. If somebody can do that, what that tells me is that they are drinking to excess several times a week at least, and they need an intervention. So you know, that's one thing that I want you to understand. The other issue is really what happens now in Pennsylvania in majority jurisdictions. There are a couple other counties other than York and Lancaster that handle things the same way we do. But what happens in the majority of your counties if you're stopped in Pennsylvania, and let's say you've had 4 prior DUIs in your record. Police officer stops you, your blood alcohol is taken some way, either by breath or by blood, and you're back out in the street the next day without any bail conditions, without any significant intervention, and charges may not actually be filed. If a jurisdiction is using blood to determine the blood alcohol level, charges might not actually be filed for months. That's why we changed our system in York County. We realized that that was happening, and that when people were stopped, they would be taken to the hospital, the blood would be drawn, it would be sent out of town to determine what the BAC result was, and we weren't getting the results back for 6 to 8 weeks. And what happened then was the hospital would mail the results to the police department. If the officer happened to be off on vacation or wasn't around, then he'd type up the report when he got around to it. And we were literally seeing someone who would get arrested in August and wouldn't have charges filed till November. That is still occurring in the majority of jurisdictions in Pennsylvania. It still happens in the majority of jurisdictions across the country. What we did was we changed our system so that now when a police officer stops somebody, they are, I can't say required, but they're told that they're to run the individual's criminal record. And if it is a second or third offense DUI or fourth, fifth, sixth, whatever, then they are taken to see a district justice that evening. And within about 6 days, we start to do alcohol monitoring. And we also impose bail conditions that require a drug and alcohol evaluation. Essentially, what should happen in all DUI cases, and really what should happen in all criminal cases, is the first question the police officer has to ask is, who do I have and what do they need? And what you're seeing across the country in jurisdictions that are doing it correctly is, frankly, police officers are doing that in all cases. They're doing it to make a decision, number one, whether the person even needs to be detained, because there are all sorts of issues surrounding that, but particularly with DUIs. You know, when you have a second offender and the statistics are out there, you know that that individual is going to repeat that offense within a couple of weeks. There has to be an intervention. If you don't do that, they're dangerous. Every jurisdiction that has adopted that policy, frankly, we call it 24/7 monitoring. And there are all sorts of devices that you can use to do that. Ignition interlock is one. You can use ignition interlock to do 24/7. You can use, in York County, we use a bracelet that's made by his company. That works. In South Dakota, what they do is they require individuals to go to a police station twice a day and blow into a breathalyzer. Every jurisdiction that has adopted that type of policy sees about a 50% drop in victim compensation. In other words, the amount of money that's paid out to victims decreases by 50%. So that's how effective these programs are. The other thing that's happened in York County is it allows us to evaluate these individuals very quickly to determine whether or not they should be in a DUI treatment court. And frankly, I believe it's one reason our DUI treatment court in York County is so successful. Since 2010, we've had over 260 graduates. We've only had 11 of those people be arrested again for a DUI. When I was trained initially, I went down to Athens, Georgia. Mike Barace was one of my trainers. The other judge who was down there was Kent Lawrence, who's just a terrific judge from Georgia. And I remember him saying, you know, I take a 12th offender into my DUI court. I'm thinking, are you nuts? Why are you doing that? And here in Pennsylvania, we can't take people into DUI courts if they're a 4th offender or a 5th offender. Now let me ask you, who needs the rehabilitation more? The 4th DUI offender or the 2nd DUI offender? Obviously, it's the 4th or the 5th or the 6th or whatever. But I'm thinking, you know, Kent Lawrence must be crazy. These people ought to be locked up forever. Number one, you can't do that. But what he said is, for public safety purposes, if we don't address the underlying problem, that person's going to get out and they're going to reoffend. Right now in Pennsylvania, anybody that's convicted of a 4th, 5th, or subsequent after that generally goes to the state prison. Over 99% of those folks go to the state prison. If they're released from state prison onto a state parole caseload, their risk or their chance of reoffending is 60, 70, 80%. Whereas you put them through a DUI court and you're talking less than 4% or less than 5%. DUI courts, drug courts are effective. Their recidivism rate's about 14%. DUI courts knock them out of the park. We're generally much lower than what the drug courts are. The other issue in Pennsylvania is when you ship them upstate, they come back into my community and they're placed on a state parole caseload. And let me tell you, state parole caseloads are overwhelming. Those officers have a high caseload. They see somebody with a DUI, that person's not going to get any amount of time compared to the robber or the rapist or any of the other dangerous folks that are on state parole caseloads. There isn't going to be any real emphasis to make certain they complete treatment. There's going to be very little drug and alcohol testing. What I've done and what York County has started to do, instead of sending folks to the state prison for DUIs, we keep them in our county prison. We allow them to work on the Outmate program, and then we have put some of them into our DUI treatment court, and then we can make certain that they get the type of treatment that they need, and we've had a lot of success with that. So that's pretty much what I wanted to say.
Thank you, Judge. I'm pleased to submit to you the following testimony in support of pretrial bail programs like Target 25 in York County and the DUI repeat offender program known as DROP in Lancaster County. As you heard from Judge Kennedy, repeat DUI offenders are a serious concern, and York County statistics are not an anomaly. Once counties dig into their data, they too will likely discover they have a problem with repeat DUI offenders rearrested while out on bail. York County proves that bail conditions require sobriety and monitoring for it to work. The use of continuous alcohol monitoring devices that test for the consumption of alcohol every 30 minutes, 48 times per day, is an effective tool at reducing the incidence of people who are charged with repeat offense of driving under the influence. This continuous alcohol monitoring technology can and should be used in conjunction with ignition interlock devices, as they are both effective tools to reduce the incidence of impaired driving. However, little, if any, monitoring of these offenders takes place while they're on bail. Although the continuous alcohol monitoring device does not stop the car from driving, it does deter the behavior of drinking. Nationally, 99.3% of scram days are sober days, meaning there are no confirmed drinking or circumvention events. When people are sober, they are not committing a driving under the influence offense. There is published research to support the aforementioned data. A study conducted by the National Center of State Courts examined the effects of scram bracelets on criminal recidivism. Flango and Cheeseman compared rearrest rates for 144 offenders who were placed on scram to those comparable offenders who were not placed on scram. The groups were matched carefully by age, race, gender, county of residence, number of prior DUI offenses, and number of any prior offenses. The researchers found that only 3% of offenders on scram recidivated while they were wearing the device, and repeat DUI offenders who were put on scram for at least 90 days recidivated at half the rate of those not placed on scram. As a lifelong resident of Philadelphia and Bucks County, Pennsylvania, I applaud you for considering replicating Target 25 throughout the state. Such legislation will improve the safety of our roadways for all of us in Pennsylvania, and I thank you for your time.
So, Judge, your program in York County and Lancaster County has been very successful, and we commend you for that. Have you shared your programs with other judges across the Commonwealth?
Across the Commonwealth?
Yes.
I have. I've presented at the State Trial Judges Conference in Pennsylvania.
So why have any of them have duplicated your program and your efforts?
I know Lancaster County
Right.
essentially has, and frankly, I believe that was instituted because there was a lot of publicity when I think it was a third or fourth offender ran through a red light and killed a family. And there were concerns with that. I will say I've always been fortunate in York. When we have decided to do something, we've been able to get a consensus, and what we did when we started the program was we pulled all the players together, the sheriff's office, the clerk of courts, the prison, the treatment providers, the probation department. I mean, for lack of a better, it really took a village. And, I probably sounded more and more like a liberal Democrat, but I'm really a conservative Republican. Now that I'm not on the bench, I can say those things. But, the bottom line is it really, if you can get the folks together, it works. The biggest issue that we would hear is, well, how do you afford this? The average DUI offender in York County is a 35-year-old white male who's making approximately $40,000 a year. Most of your DUI offenders are working, and frankly, what we found is most of these folks were spending $60, $70 a week on alcohol. And I can't tell you after we started this program, even the folks that didn't get into DUI court, how many people would come in at sentencing and tell me how much better their lives were now that they finally had become sober. You know, I heard, you know, I had my child's first birthday where I was sober. You know, this has happened, that has happened. And frankly, it's forced sobriety, but that's what a lot of these folks need. And, you know, that we have not had many issues with self-pay. In fact, our vendor who handles it is here today, and I understand they have a very high rate of self-pay.
Representative Dawkins.
Thank you, Chairman. Thank you, gentlemen, for your testimony. I got a few questions. First, let me pose the question this way, or start the question this way. In your opinion, do you feel that the breathalyzer that's installed into the vehicle, do you see a drastic decrease in individuals who have that device in their car?
Ignition interlock can be an incredible tool if it's used appropriately. Really, for any of these tools to be used appropriately, that satisfies the monitoring requirement. You know, the other two requirements that you really need are some supervision and some treatment. In Pennsylvania, I could tell you in the past when we had ignition interlock, what was happening is the device would be installed in the car, but nobody looked at it. Connecticut's got a really great program. They only use it with third offenders, but any third offender that's arrested in Connecticut for a DUI loses their license automatically unless they put an ignition interlock on their car. When it's used correctly, which is what Connecticut does, they monitor that. So, in other words, you own a car, or they put ignition interlock on your car, they start to monitor it. If you haven't driven that car in 3 days, you get a phone call. You know, how did you get to work yesterday? How did you do this? You know, that type of thing. So you need to make certain it's being used. Or the other place where it's been really effective as 24/7 monitoring is you'll have the ignition interlock on your car, and you realize when you sign up for that you may get a phone call at any time, and you're going to have to go out to your car and blow into that device. So that it's that way it operates as a 24/7. A lot of the ignition interlock programs too now, and it has to include this, it has facial recognition software with it. So I couldn't, if I got a phone call at 2 o'clock in the morning saying I got to go blow into my car, I couldn't send my wife out to do it. So yeah, ignition interlock can work, but again, it's got to be monitored.
And that particular device, that is, the cost is 100% on the individual and not the municipality, is that correct?
Generally, that's how most of the ignition interlock programs work. Generally, that's how most of the 24/7 programs work. Now, the other thing that I think makes the York County program effective is we require not only the alcohol monitoring, but we also do drug testing. Because what you will see is if an individual is forced to be removed from alcohol, they will start taking drugs. And as I said, most of our folks that come through our programs have some sort of drug in their system combined with the alcohol. So to really be effective, you've got to be doing the drug testing along with the alcohol monitoring.
Because what I'm thinking about, and I'm just sitting here thinking about common sense ways to kind of approach this issue, and I was hearing earlier around the developing issue around alcoholism is developed in the younger generations, moving into maybe their adulthood, where we see young folks who may have not been in the event of driving have these severe cases of, you know, their blood alcohol ratio. My thought process from potential legislation is that individuals who may have got caught with a DUI was not in the act of driving, underage or like, that we would have some provision to say upon driving age or upon acquiring a vehicle or acquiring a license, that the interlock has to be a part of their initial probation period to show that they are willing to take the necessary steps. Because my colleague, the story he told around the young kid for the first time driving out the gate, and he's loaded, no one ever monitored it because all of his offenses has been prior to him having a driver's license. This at least gives us some assurances that young folks know that we're going to take this seriously. And I think it's very embarrassing if you're trying to go out with your friends and you got to blow into a tube before you guys go to the movies. that may be the deterrent we need to prevent some of these tragedies that we have seen throughout the Commonwealth and in the country.
Ignition interlock definitely is a very important tool. Again, one of the issues with it is what do you do with folks that get DUIs that don't have cars? So again, you really need the ability to have some flexibility and be able to use any of these types of alcohol monitoring tools. I know, for instance, in our DUI court, when we have the folks wearing the bracelet, I know they're not drinking. And, I know they're generally not going to drink. If they do drink, we'll know about it right away. The downside, the ignition interlock folks will say, well, there's nothing about that bracelet that's going to keep them from getting in a car and driving. That's true. But there's also nothing that keeps a person who has an ignition interlock from taking their sister's car or their mother's car after they've been drinking. There's no foolproof way, but I think what you have to keep in mind is you have to have the flexibility. And then the real issue is you need to address the treatment needs of the individual because they vary. Somebody asked about the DUI offenders and ages of DUI offenders. Actually, NHTSA now has some statistics that shows that DUIs are decreasing among the age group of 18 to 35. They kind of think that's due to Uber and Lyft. I have a son who had his first legal drinking summer this past year. He came home from college. I said, Christian, said, you or any of your buddies need a ride home, call me any time of the night. I don't care. I'll ask no questions. I'll come get you. I'll drive you. I don't want you drinking and driving because, Dad, we have Uber. And that's what they do. They go out for a night. 6 or 7 of them get into an Uber XL. It's $5 a piece.
Thank you.
Chairman Keller.
Thank you, Mr. Chairman. Mr. Van Houten, quickly, because I know the chairman are worried about time. It's been testified that the cost of the scram bracelet is bore by the offending. What is the cost? What is the actual cost to an individual?
In our county, if they're in the DUI court program, it's $9 a day. If they're not in the DUI court program, it's $12 a day. What we do, the vendor looked at the poverty rate in our county, and I think the poverty rate in our county was 5%, so they give us 5%, quote, free beds. So those that are unable to pay, we have them utilize that system.
And you also testified that the scram bracelet is just for alcohol.
Correct.
And that you need to monitor
in addition,
intake of drugs. Is that an additional cost to the individual?
It is. The drug testing is an additional cost. I believe that's about $3 per test. And they can be tested as many as 3-4 times a week, and we test 7 days a week. You're not doing effective drug testing unless you're testing 7 days a week. You've got to be able to test 7 days a week to do effective drug testing.
So it would be upwards of $18 a day?
No. Again, a drug test, well, the way drug testing works is they call a phone number, and that phone number will tell them whether they have to report for a drug test or they don't. The most they would be tested generally is 4 times a week. It could be more than that. So 4 times a week would be $12 a week.
That's just for the drugs?
That would be the maximum.
That's just for the drugs?
That's just for the drugs.
So they would have to do both to be effective, you said?
My opinion is, yeah, if you're going to do the alcohol monitoring, you also have to combine it with drug testing.
So what cost would that be to the individual a day to have both of them?
In general, your offender is going to be looking at about $90 a week, I'd say.
$90 a week?
Yep.
Upwards to $400 a month. I'm sure it's a mortgage payment for some people.
It's certainly a car payment. Like I said, yeah, I guarantee you somebody who has a BAC of 0.16 or above is spending $50, $60 a week on alcohol alone. Not to mention what that's going to cause them to spend on other things after they've had that amount of alcohol.
Okay. Thank you, Mr. Chairman.
Representative Costa.
Thank you, Mr. Chairman. I guess this question is directed to Tom. I know in the past I've seen devices which work like ankle bracelets and stuff, which actually measure the alcohol that comes through the system, and it's on 24/7. Okay, and if you drink anything, then it notifies your carrier or whatever. Your system, how does it exactly work? I mean, and why would it be better than a system like that?
So our bracelet uses transdermal technology. Basically, alcohol is excreted through the skin, and it tests for that every 30 minutes around the clock, and it provides those results through our platform. We also provide data analysis of the actual event and the drinking event to determine whether or not it's environmental or it's actually a drinking event, if you will. So the technology is built to test around the clock and provide not only results but confirmation of drinking events versus environmental events.
All right, that's exactly what I was thinking, but I wasn't quite sure. I wanted to make sure to clarify that. Thank you, Your Honor. Thank you, Chairman.
Representative Quartz, then White.
Thank you, Mr. Chairman. Thank you, Judge Kennedy, Mr. Van Houten. More on the Scram bracelet. Are there two different bracelets, one for alcohol and one for drugs?
Yeah, so for the record, our bracelet, the Scram device, only tests for alcohol. So in our case, that device would only give you results of alcohol or compliance around alcohol monitoring. I think Judge was referencing the ability to test for drugs while that offender was being supervised both on the bracelet and through drug testing. But our bracelet, our technology only tests for alcohol consumption.
Okay, and does the bracelet go on the wrist or on the ankle?
Goes on the ankle.
Goes on the ankle. Is it locked on there so they can't get
Correct.
it off? How can they cheat it? There got to be some way they figure it out. Is there a way to beat this, or have you made it foolproof?
Well, nothing's foolproof, but we've made it very difficult. After roughly 15 years and thousands of events, we've been able to, I think, very accurately ascertain whether or not it's actually a drinking event and whether there's tampering. There is tampering technology built into the bracelet to help notify you that something could be taking place. But the actual technology, the science of technology has been proven. And so short of anything malfunctioning on the technology side, you're getting an accurate alcohol consumption statement.
Okay, so there's monitoring that the bracelet's working accurately.
Correct.
There's feedback all the time electronic.
Correct.
To a database somewhere.
Correct.
Okay, and you have this all over the country?
Yes, we do, and other countries as well.
Okay, thank you. Thank you, Mr. Chairman.
Representative White.
I just wanted to ask whether or not you, I guess, felt the cost of the treatment for your county with regard to those people who have to go through this process and who need it. Is that a significant burden for your county, or do you think it's worthwhile? And we don't, in comparison to the jail side, obviously.
I think what you have to realize is that in Pennsylvania, treatment's mandated for anybody that's convicted of a DUI. So, we spend the same amount of money on treatment that we always did. The difference is it's much more successful, particularly when somebody's in a DUI court, because number one, they're staying sober as they're going through the treatment. Number two, they're being supervised. So if they miss a treatment session, they're back in front of me within a week, or they're back in front of the DUI court judge within a week. Whereas traditional probation, where they've been placed into treatment after they've been sentenced, they may miss a treatment session, and the judge may not hear about it for 6 weeks to 2 months, and then he may schedule a probation hearing 6 to 8 weeks after that, and they may never complete treatment because until their probation is violated. So we spend the same amount of dollars. It's just far more effective, and frankly, we have the money in the system to do all of this. The reason we aren't able to do it right now is because we're sending too many people to the state prison system that don't need to be there. As you all know, we were able to close one state prison, and I think that saved $60 million a year. If that money had been sent $1 million back to each county, can you imagine what kind of programs we could have done? We almost need reverse mandatory sentences, so that you can't have a judge from York County who sends a woman who's in front of him for the 18th time on a prostitution charge up to the state prison system. Or he can't send the drug-addicted man who comes into his county on his 20th shoplifting case up to the state prison system. John Wetzel has told you all those things. John Wetzel's a big believer in the fact that we ought to shut down some more state prisons. But until we change the sentencing guidelines in Pennsylvania, until we stop sending people up there for a year and a half, 2 years, it's not going to happen.
And I don't know if you could maybe put together a timeline for us just so that we can get a good sense as to, when the sentencing takes place versus when you're able to detain the person and all those steps in between, so that we can make sure that there is an effective program that can be modeled across the state for the benefit of the committee?
Well, again, with DUIs, what you're seeing, depending on where you're at in the state, frankly, I saw a county receive an award because their solution to, really what happened was one of the problems we struggled with was years ago, because the way the DUI statute was written, I'd get a DUI tonight, I'd get another 2 weeks later, I'd get another 3 weeks later, end up with 3 offenses. One county's solution to that was they speeded up their DUI processing, which mean that they went from date of arrest till plea and sentencing of a year down to 6 months. In York County, we always did it in about 3 to 4 months, date of arrest through sentencing. I should say we started to do that from charge filed to sentencing. We processed them pretty quickly. But again, years ago, back in 2008, date of arrest might be August, charges weren't filed till November, okay? And that's still happening across the state. So exactly how much time it takes depends on how that county is handling their criminal cases. As you know, in Pennsylvania, the charge has to be disposed of within 360 days of the charge being filed. But again, with DUIs, many counties aren't filing those charges until weeks or months after the arrest. So exactly how long it occurs from the time the crime happens until sentencing, I can't tell you.
Any other questions? Well, thank you. I just want to mention, I'm just surprised that other counties haven't picked up on the success of the programs that you've
It is a lot of work. And, you know, I presented, when I presented at the State Trial Judges Conference, we had a judge who's the only judge in that county. He says, I don't have time to do this. You know, I can tell you, when I ran it in New York, I would get memos and emails from probation officers on a regular basis, and I'd respond to those within an hour, 2 hours, because that's what you need to do. But
well, thank you, gentlemen. Appreciate you being here. Our next testifier is Dr. Jonathan Beatty, Medical Director of Sandpiper here in Philadelphia. Is that correct?
Yes, sir.
All right. Good morning, and you may begin.
Good morning. Thank you, everybody, for the invitation. Thank you especially to Honorable Kennedy and Honorable Barrett in particular for your testimonies.
Could you pull your microphone a little closer?
Sure. Are you able to hear? Is that better?
That's better.
Just a little bit about myself, just so you're aware. So I am an addiction psychiatrist. I'm board certified in psychiatry, addiction medicine, and pain medicine. And I sort of fell into this process by way of pain management. So I was working at Jefferson on the faculty there, treating pain management cases and learning how, and this was before the quote-unquote epidemic currently. So at that time, I was seeing a lot of patients that were prescribed opioids legitimately. They were not intending to get more than what was prescribed, but sometimes developed an addiction problem as a result. And then from there, they would come to see me after seeing probably a dozen other doctors that kept escalating their doses. And what I learned through experience was sometimes this is not the right solution to the problem, and I started weaning people off of their opioids, and lo and behold, they were doing better. They were having better results, and they were gaining more function in their life, which is really a better metric of success than a pain rating scale. So as a result of that, I kind of moved into treating addiction. I got board certified in that as well. And I started working for some of these programs, and so what I wanted to talk about, everybody talked about sort of the legal side of it and occasionally mentioned something about treatment, but didn't necessarily articulate what treatment means. So having worked in some of those places prior to starting Sandpiper MD, I can tell you those places are not necessarily the best places to get, well, they may be great places and they may provide treatment, but they are not necessarily the places that provide the best successful outcomes. Part of the reason for that is these programs are not necessarily evidence-based. So the idea of a 28-day or 30-day program, there's no science behind that. There's nothing that says if you go to a program for 30 days as opposed to 26 days or 41 days, you're going to succeed. That is kind of a made-up number. It's a bit arbitrary. The other thing to talk about is the idea of a 12-step model or an abstinence model. And so there was one mention, I think, of some treatment centers. And I just want to list from a website, I'm not going to say the name of the website, but what they provide as treatment services. So group therapy, individual therapy, That obviously is good, but it doesn't say that those are by licensed clinicians that have been actually trained and know what they're talking about and know how to help people through those problems. It talks about in-house 12-step meetings, which I'm not going against the 12-step approach. It has saved thousands and thousands of lives, but it is not an evidence-based practice. It is not based in science. It's founded in more or less a belief system. It's a philosophy, and with that philosophy applied, many people have been saved, but with science applied in addition, even more have been saved. Chiropractic care, equine-assisted therapy, yoga, spiritual services and counseling, art and music therapies. So those sound nice, but there's not a lot of evidence to support those. And then as a footnote, as is most of these, medication-assisted treatment. So I wanted to talk a little bit about that as well. I think that, at least with respect to alcohol use disorders and opioid use disorders, there are very good medications available to improve the outcomes. So everybody was talking about, in fact, even the monitoring system that was just reported on is a very good tool, but by itself it proves that somebody isn't drinking. Abstinence isn't necessarily the goal. Harm reduction is the goal. We don't want people getting behind the wheel or doing something else that's going to harm other people. We have a public safety issue that is at stake here, and then we absolutely have to protect our society. But if somebody has 2 or 3 drinks in their home and they're going to work every day, that's not really, in my opinion, a problem. I mean, it may be a problem, but it may not be a problem. So proving that they've had 0 alcohol and not including treatment to help them have 0 alcohol is really setting them up for failure. So I was impressed, I guess, that the fear of losing their license or some other legal ramification from the ankle bracelet being detecting alcohol would deter such a significant number of people. That is astonishing, and that's frankly more impressive than the average clinical results, meaning when there's not, I guess, a legal ramification and somebody's just coming in, let's say, going to a treatment program without medical assisted treatment and trying to change their drinking or drugging behaviors. So then I would add that applying medical science, it's critical with good psychosocial support, and 12-step peer support models are part of that. Other models, such as the Brenda model, which is an acronym, but the point being that it's really a supportive way of sort of aligning with the person and trying to help them understand what's going on and figuring out the biological component, which would be, say, the genetic family history of addiction, the psychological component of it, maybe there's an underlying depression or an anxiety, and then the social aspect of it, of where are they using these drugs or alcohol, and learning about those things in each individual case so that you can help fix those problems. The other thing that's worth noting is that somebody said, I think, if you get a DUI and it's not processed for 2 weeks, well, if you have a DUI and the reason you got the DUI is because you have an alcohol use disorder or a substance use disorder, let's say the ones that have physiological dependence, such as alcohol and opioids, even if you have the best intention of, oh my gosh, I just got arrested or whatever, got pulled over, and now I really shouldn't drink and drive, you go to sleep that night, although unfortunately I've seen patients that have had alcohol that same night, but they go, or the next day. They go to sleep, they wake up, now they're in alcohol withdrawal or opioid withdrawal. So now they're going to get that drug, that substance, whether it's alcohol or opiates, because if they don't have it, they actually could die. So at least with alcohol, there can be life-threatening alcohol withdrawal. So we're imposing a law saying that you have to be abstinent, but we're not providing a detox service. So we're potentially creating a scenario whereby they have alcohol withdrawal seizures, delirium tremens, and can die. With opioids, the likelihood of dying from an opioid withdrawal is very, very low. Certainly it's an unpleasant withdrawal, but regardless, I think it's critical that we have a detox associated with this process so that we can really give them the best opportunity to succeed, whether it be abstinence or harm reduction. They're much more likely to stop using the substance if they're not withdrawing from it. That's a medical fact. In fact, the driving force for using and even the illegal behaviors, such as criminal behaviors, is often not so much because they're wanting to get high, it's because they're wanting to avoid withdrawal. So it's an anti-reward system. There's very good neurobiological evidence of that. So what I would say, in addition to these types of treatments that need to be very supportive and very evidence-based, therapies such as cognitive behavioral therapy, which has been applied to multiple types of chronic health disorders, including substance use, is the right medications. And so, for example, there's a very underutilized medication, and by the way, I should add, I have no financial disclosures, so everything I'm reporting to you today is based on my medical opinion and the medical literature. I'm not being influenced in any way by any finances. I say that that's sort of the protocol in an academic presentation. I realize this is a little bit different, but I wanted to clarify that. So there's a medication that is called naltrexone, and naltrexone is an opioid blocking medication, but it is not an opiate. It is not a mind-altering substance. It does not influence you or impair you in any way from operating a motor vehicle or carrying out any day-to-day activities. That is very unusual compared to the more common types of treatments for opioid abuse, such as methadone maintenance programs and Suboxone-type programs, buprenorphine programs. So naltrexone blocks opioids, and it is FDA approved for the treatment of both alcohol use disorder and opiate use disorder. So we have a single agent that can be used to treat two of the biggest problems in our society from both a substance use perspective and apparently from a driving impaired perspective. And this is an agent that will not impair anyone, so it won't affect their ability to safely operate a vehicle or a machinery. It also helps with cravings, by the way, so it helps reduce people's interest or urge and preoccupation with using and obtaining the drug, including alcohol. Now, the problem is not everybody takes this medication every day. So once you've had a detox and now you're on the medication, you have to take a pill every day, and you have to remember to do that, and you have to choose, do I take that pill or do I go wait a day or so until it wears off and get the alcohol or drug? So if you don't correct the underlying disorder, such as an anxiety problem or a depression problem or whatever else is going on, more than likely they're not going to take the pill and they're going to go on to use the drug, which unfortunately is a quick fix for them to relieve their suffering and their pain. I'm not saying that there isn't a major societal problem, that we have to protect our society against these people from harming them, of course. But we also have to recognize that they themselves are probably in pain in some way, and that they don't really want to be addicted to this substance, most likely. I think one of the judges said something along those lines, particularly with opioids compared to alcohol, but I would argue with both. So correcting the underlying problem and then offering a solution which is comprehensive, meaning that you're looking at all of those other psychological problems that might be occurring and treating the medication. And oh, by the way, do I have to take a pill every day? Well, guess what? There's something called long-acting injectable naltrexone that lasts for a month. The brand name is Vivitrol. I believe there's not a generic yet available, but it lasts for about 28 days. When you're on that medication, you're not getting high from opioids. So in other words, if you get an injection for those 30 days, you know you're not going to be driving under the influence of opioids, because if you took opiates and then drove, you would just be like driving. It wouldn't be under the influence of opioids because they would be blocked by this medication. A similar application is true for alcohol use. In other words, with that medication, naltrexone, whether it's oral or injection form, will block some of the euphoric effects of alcohol, and therefore you're going to take away some of the interest in drinking and the preoccupation for it. They're not going to get what they're looking for out of it, and so they're less likely to drink. And I've seen this in my clinical practice day in, day out, and I see people's lives transform with a combination of a medicine like Vivitrol or the oral naltrexone, as well as psychosocial support that has to be comprehensive and regular. Drug monitoring, in other words, urine drug screen, saliva testing, ankle monitoring of both alcohol and other illicit substances is definitely a part of that standard of care. But I would argue that without the other components, it really is falling short of the mark, and we're not treating these people that really need our help. So I think it's, in summary, very important to have medical treatment for what is a clearly defined medical disorder. There's good neurobiology of addiction studies and science to back that up. And I think that they should incorporate, of course, protecting our society, but also protecting the individual, which in turn helps society. So it's really an all-around benefit. So I can go on and on and on about that, but I'd rather open it up to questions if there are any.
Are there any questions? Representative Knowles.
Thanks, Chairman. And Doctor, thank you so much for your testimony. You had talked about two topics that I found rather interesting, and I don't know whether you'd want to further comment on them. The first was the comparison of the seizure disorder, and we all know, because we have people coming into our offices who've had seizures, and their doctor will suspend their license for 6 months, maybe a year, and it's got to be proven that that disorder is cured before they're reissued their license. And you compared that with, you thought that people who have substance abuse disorders should be treated in the same fashion. So I just wondered if you had anything more to say about that. And the second has to do with, we hear many times from people who run treatment facilities that the problem is the length of time that they go for treatment. And you had noted in your testimony that, that there's no documented proof that the length of the treatment really has a lot to do with any type of a cure, any type of a solution. So
let me clarify that point, and then I'll go to your first question. So the length of treatment at an inpatient facility is what I should have clarified, is what really doesn't have a defined timeline of success. So 30 days inpatient. As far as outpatient treatment, which I think is actually the more appropriate setting for the majority of these. So I would argue that in a minority of cases do people need inpatient treatment. And in my practice, I provide the whole gambit from outpatient detox, ongoing therapy, through the course of what is generally recommended to be about 12 months. So actually, and I think one of the judges said 2 years. That would be fantastic if we could get 2 years, but I would go for at least 1 year with combining medications and psychosocial support, psychotherapy, et cetera, for 12 months or longer does actually show significant success rates by comparison to other less structured or less professional-based programs. Going back to your first question about the seizure disorder comparison, I don't mean to compare them in the sense that they're the same, because there is a difference in the sense that people don't generally choose to have a seizure disorder. You might argue they don't choose to be addicted to a substance, but they are at some level making a choice to consume that substance at the minimum for the first time, but even probably ongoing. So in that sense, they are different. However, to your point of when you have a seizure disorder, there is a serious danger to society when driving and having a seizure. And so you have to demonstrate a period usually of 6 months where you have not had a seizure. That includes medication, right? So you could choose, if you had a seizure disorder, you could choose not to take medication, anti-seizure medication, anticonvulsant medication. But in all likelihood, you'd have another seizure again. And so you might say, well, I really hate these medications. I'd rather risk having seizures. I would argue that you have a right to do that as an individual, but I would also say that our society has a right to prevent you from getting behind the wheel, because unfortunately, if you're driving while you have a seizure, you can very easily kill yourself and many, many other people around you, much akin to a drunk driving accident. So I think there needs to be an option perhaps with the treatment and particularly the medication towards acceptance of those in order to get your license back by a certain period of time, something along those lines. Yes, we could put people in prison for a life sentence and they're never going to affect society again as far as having a drunk driving accident, but at what cost? So can we come up with a more reasonable approach that has some good science behind it, of a treatment paradigm that has been proven to show success rates that are superior to non-medically assisted programs? And can we use those as a benchmark to, I guess, in a way, convince or cajole people to accept those as a way of getting their lives back? And really selling it in that sense, that we're helping you get your life back. You don't want to lose your license because you don't want to lose your job and there isn't mass transit in your particular county or wherever. We don't want you to lose your license, because if you lose your livelihood, you're going to go drink again or use drugs again, because now what do you have left? So we need to, those are the measures. We need to get people working. We need to repair the relationships that have been damaged from the deception and from the other components of the addiction. We need to get them to understand how to to budget their money properly to pay their bills as opposed to buying substances. And by the way, they talked about that habit, 30, 40, 60, 80. I have patients that come into me and they talk about the cost of treatment, but they're spending and they're finding the money, $150, $300, $600 a day to buy illegal oxycodone on the street. And then what happens, unfortunately, and this is kind of a different story, but that segues into becoming too expensive and they've lost their job. And unfortunately, heroin is cheaper than non-medical oxycodone. So if they're not breaking a law by trying to doctor shop to get a prescription and they can't afford to buy it on the street, and they're going to withdraw severely from the opioid, they're going to potentially commit another crime in order to get the money to buy it off the street, or they're going to go to heroin, which is unfortunately somehow cheaper. And so 100%, by the way, in Philadelphia, of the opioid overdoses last year that resulted in death had fentanyl in them. So fentanyl is a synthetic opioid that's 100 times at least stronger than heroin, and it is lethal, and that's what the majority of this heroin is. This is really kind of a different topic. I mean, I can talk about that for a while too, but just the point is, that's the path that they're heading towards if we don't get ahead of it and say, all right, you're impaired, we need to do something about it, we need to protect society, but we need to give you the right treatment so that you don't wind up in that case.
Thank you, Doctor. Thanks, Chairman.
Representative Corbett, question?
Sorry, Mr. Chairman, I didn't hear you. Thank you for your testimony. I'm going to take the opportunity here while you're here because of your expertise to ask a question that interests me, and it is related to the opiate crisis, and that is any research that's being done in the field of analgesics that are not related to pain, pleasure. Is there anything being done to develop anything like that so people who do indeed have serious pain are able to get treatment?
Absolutely. So the reality is that opioids are not necessarily the best option to treat chronic pain. In fact, there is something called opioid-induced hyperalgesia, and what that means is an increased pain due to the opioids. In addition, they cause hypogonadism and other sorts of long-term problems, bone demineralization problems. So being on opioids long-term, even as prescribed, is not very good for your body. And so it's not necessarily a good health approach. Now, for acute pain, they do work pretty well. But the quandary is, what do we do about the chronic pain? So when acute pain becomes chronic pain, what do we do about it? So you can't necessarily give somebody a nerve block. And by the way, for acute pain, if you're in a hospital setting or if you're, theoretically any physician could do a nerve block for most areas of so regional anesthesia, that's called. So there's nothing addicting about that. You give an injection at the point on your body where the pain is, it blocks those nerves. The problem is it only lasts for a few hours. But for, a brick that landed on your toe and you're in the emergency room and you need to get the fracture set, regional anesthesia is fantastic. And by the time when the fracture is set correctly, the pain should resolve. So in that setting, you don't even need to be exposed to opioids. So there are a lot of reasons why you don't need to be exposed to opioids in the first place. Furthermore, nonsteroidal anti-inflammatories, which are over-the-counter, such as Advil and Tylenol, although that's not an NSAID, but they are phenomenal analgesics. So there are a lot of reasons why you can avoid, and that statistic that the judge mentioned earlier, I think it's over 80% of the world's opioids are consumed by this country. Why is that? Why do we feel the need to treat do we just have more pain in this country, or do we feel like the rest of the world, where they don't even necessarily have the same safety requirements for things, they must have more injuries, and there's certainly larger populations, and yet they're not consuming opioids? How are they surviving with that pain by comparison? So there's certainly a perspective on pain in this country, perhaps, that it needs to be zeroed out. And the reality is, from the pain management side, that's not a reasonable goal. It's not I shouldn't say reasonable, it's not a goal that you should look for as a metric of success. You should look at functionality. So the patients that I was treating, and I still do have some chronic pain patients who are thankfully off opioids, they look at, what can I do today? Can I work today? How do I get there? And so perhaps one patient coming to mind that has to travel to New York. So for her, getting to New York on public transportation is very painful for her. So can we make an accommodation for her so that she doesn't necessarily have to go to New York as frequently, or when she goes there, she can have a better place to sleep overnight so that she doesn't wake up with back pain the next day that's worse from what it was before. So there are a lot of, I think Dawkins said common sense things that we can use to try and mitigate the pain without using opioids. And then to answer your question, there are absolutely research, there are some interesting things happening. There's a particular sea creature that has some sort of stinging ability that numbs its prey. They're looking at that and seeing if they can, then it's in more advanced stages of testing. It's not an opioid, it's not addicting in any way, and it seems to have some very good analgesic properties. So in addition to the numerous things that already exist, there are some things in the pipeline as well.
Could I ask a follow-up to that as well?
Go ahead.
You talked about naltrexone. What about Suboxone, and what are the differences in the two and the pros and cons of each? Because we hear an awful lot of the negatives about Suboxone, at least I do in my area.
Absolutely. I'm glad you brought it up. So in my practice, 95% of my patients, I would say, are the buprenorphine route, the Vivitrol or naltrexone route, and maybe 5% are the buprenorphine Suboxone route. And why is that? Because you can use buprenorphine as part of a detox. That's a totally different thing. But what you're asking about really is maintenance treatment, so ongoing. So one of the initial challenges is for about a week to 10 days from your last use of opioids, you need to be detoxed in order to get onto naltrexone, whereas you can start the Suboxone sooner. The reason being both can precipitate opioid withdrawal if given too soon. But you can get started sooner. So that initial period is really the key difference, but there are a lot of ways around that. And as I said, I do this in an outpatient practice where people are in the real world, in the lion's den, where they might even be living with somebody who's actively using, and I'm trying to detox them. That's a lot more challenging than going to a country club where you're getting massages every day and detoxing at the same time. So it is possible to do it, is my point. And nonetheless, they just recently published in The Lancet, which is a very good peer-reviewed journal, that once you get past that detox period, the success rates are very similar, and I would actually argue better with naltrexone, because at the end of the treatment period, if you're on naltrexone and you decide to stop, remember, it's not an opiate. You don't become dependent on it. The day you stop is the day you stop. You don't have any withdrawal from it. It's easy to stop and get off of it. So if you're I don't want to say cured, but if you're at a point of stability where you may no longer need it, you just get off of it. If you're on Suboxone for a year, now you have a real bear to get off of that Suboxone. That might take you another 6 months to do it with the least amount of risk possible. Sure, you could get off of it in 4 to 6 days, but you're probably then going to relapse, which is that's clearly not the outcome we're looking for. So that's sort of the biggest difference. Then there's a legal component of it. There's no street value to naltrexone per se. I would love it if the world of drug-addicted people abused naltrexone. That would be the greatest thing in the world. It's not going to happen. But they will abuse Suboxone, and it has a street value of roughly $8 per strip, so, which is how it's usually taken under the tongue, or the tablet form under the tongue, either way. So what happens is somebody goes to their doctor. Well, let's start with the better analogy, or the proper analogy, which is somebody goes to their doctor, they're addicted to opioids, they get on Suboxone and they take it every day as prescribed and they do great. If that were the majority of cases, I wouldn't argue against it, but that's the minority. Unfortunately, the majority is there's an interval period where the doctor sees them more regularly, and then once they've demonstrated, usually through urine drug screens, that there are no other substances on board, they spread those appointments out to every month or every couple months, and what happens is, unfortunately, many of those patients will get that prescription, which now has a street value. Let's say they have 30 days times $8. So now if they sell those on the street, they might keep 5 or 6 of them for themselves. They can sell that, use that money to buy illegal drugs, such as heroin, and then right before their doctor's appointment, they can take those last 5 that they reserved, detox themselves from the heroin, and get back on to the Suboxone, so that when they see their doctor, their urine drug screen shows just Suboxone and no heroin, and it looks like treatment success, but in reality, it's drug dealing.
Chairman Taylor.
That does not happen with naltrexone and Vivitrol.
Doctor, why not
more popular naltrexone? Why is it not? I mean, you know, we're in some of our areas, we're the epicenter of the addiction and the deaths. But, I mean,
Yeah.
it doesn't seem like it's a normal path of recovery.
This is my uphill battle, and I don't know the answer. I think partly is education on the part of the medical community. So unfortunately, there are not enough highly qualified addiction treatment providers. There are a lot of family doctors who have maybe seen it in their community and realized a need for it, and so they're sort of trying their best. And to get, you know, so you don't need any, REMS is like a risk evaluation mitigation strategy that the DEA has implemented. So you need to do certain REMS procedures of education in order to prescribe certain types of medication, anywhere from chemotherapy drugs to certain opioids. And there's an 8-hour buprenorphine course. So basically, somebody with zero training in addiction, other than the fact that they're a licensed physician, can take an 8-hour course and then prescribe Suboxone. There's no such requirement for writing a Percocet prescription, by the way. So, and unfortunately, oxycodone is, at least from my experience, the #1 drug of abuse as far as opioids go that are in the pill form, you know, that are from a, you know, pharmaceutical, not street heroin. So, and oh, by the way, a lot of times they're pressed illegally and they look like oxycodone, but when I get the urine drug screens back, they're fentanyl and all sorts of other things that don't even have oxycodone in them. So people are taking them thinking they're from a pharmacy and they're not, and they could easily overdose and die. But getting back to your question, Vivitrol is a little bit complicated to use. It does require that initial detox period, but I mean, it would be very easy to design a program. I mean, and I'd be happy to be part of a pilot, you know, designing a pilot program to educate people on how to use that. And in fact, there is one of my mentors works out in Plymouth Meeting, has a nonprofit organization that is set up exactly just for that, but he has trouble finding people to get the training or to even know about it. So, and unfortunately, even in the medical literature, you see everything about the buprenorphine products and then a sort of little footnote and, oh, and also naltrexone, or, you know, injectable naltrexone, which is the opposite. Now, why is that? We could get into some speculation about that, but you know, we're in a government building, so I'm not going to. But nonetheless, it happens. So even though the literature is somewhat influenced, but when they actually do head-to-head trials and then when they actually demonstrate the outcomes, the naltrexone really is a superior product. So why isn't it being used? I don't know. It should be. I wish I could give you a better answer than that. It's really falling short, you know, in the treatment community, meaning that my peers are not doing what they should be doing because I guess they don't know how to. It's a little tougher sell. That may be another side of it when you're talking to a patient. You know, the stages of change where you're trying to get them ready to move into an active role in getting away from the drug use. It's a little bit of an easier sell in the short run to say, well, we'll put you on Suboxone, it'll sort of feed the beast, you're getting a drug, an opiate, it's just a more safe and more regulated opiate. But you have to look long term, the short game and long game. In the short game, maybe that's true by comparison, but if you can get somebody to stay on Vivitrol for 3 months, 6 months, or like I said before, 12 months ideally, that long game compared to the other arm of the treatment pool with the buprenorphine, they're going to be so much better off, their lives are going to be better, they're going to be happier, they're going to be productive members of society, they'll have repaired those relationships with their families, with their you know, loved ones, and you know, it really is, I see it's the most rewarding thing I see, and it's much more rewarding, frankly, than the buprenorphine route.
Representative Heffley?
Thank you, Mr. Chairman, and thank you so much for your testimony. I mean, I would recommend everybody, I'd like to sit and talk to you for 2 hours, quite honestly. I think you're really, a lot of people need to hear this information. But I'm going to take it back a little bit to the DUIs and talk a little bit about Suboxone and methadone. And we have had several overdose deaths because of Suboxone and methadone. And the difference is that's still an opioid-based product, and it's a with the methadone and Suboxone, even oxycodone, when you get a prescription filled and there's a label on there, do not operate heavy equipment or do not operate a vehicle, you know, it's up to that person that's prescribed that to not. Is that the same with, if somebody's going through Suboxone treatment or methadone treatment, what can we do to ensure that they're also not driving, because it is also altering their perception and ability to operate a motor vehicle?
Absolutely. It's a very good question. So the fact of the matter is if they're being prescribed and even taking as prescribed a treatment for opioid use disorder that includes either a buprenorphine product, which is Suboxone is one of the brands of buprenorphine, or methadone maintenance programs, they are, in a sense, addicted to opioids, and they are getting some of the negative effects as far as impairment goes from those opioids. And so there is potentially a risk for their coordination in operating a vehicle, which again doesn't occur with naltrexone. But was your question, how do you safeguard against that?
Yeah, what can we do to better safeguard? We had an incident this week in the district I live where a truck driver actually OD'd while driving a truck and crashed into a house. And I come from that industry, and it's insane that that's happening, because that's something that there's been mandatory drug and alcohol testing in the commercial licensing for decades now, but yet now we're seeing this come up. So what can we do to these folks that are going through that type of treatment to ensure that they're not going to be on the roads? We're seeing more and more of DUIs are actually non-alcohol related DUIs. More of them are opioid DUIs.
So I don't have the exact statistics, but I would presume that these opioid DUIs are not very many of them are from prescribed Suboxone necessarily, but they may be mixed with somebody that's taking, maybe they are taking that as prescribed, but they're also taking something like Xanax or another benzodiazepine that is substantially limiting their coordination or possibly even sedating them to the point where they're falling asleep at the wheel. And that has a synergistic effect in those negative consequences with an opioid such as buprenorphine or methadone. So if somebody's on one of those maintenance treatments for the opioid abuse or dependence, and they're getting either by prescription or by the non-medical street purchase something like a benzodiazepine, now you're really playing with fire. You have two intoxicants on board basically while you're driving. So I know, for example, with pilots, they can't be on Suboxone and have their pilot's license, at least commercially. So I don't know what the case is for CDLs. Apparently, I guess you can be on Suboxone or a buprenorphine product.
I wouldn't think so. I mean, most of the carriers or companies, obviously it's insurance related, and if you're on any kind of medication like that, it's your obligation to report that to your employer and then not operate that vehicle while you're taking those medications. But it's not just CDL, but for anybody. I'm just looking at what can we do to ensure that if people are going through those treatments, is that something that we need to monitor? Obviously, I supported the ignition interlock when we passed that legislation, but how can we don't have that ignition interlock for opioids or Suboxone or methadone or anything like that. So it was just I wasn't sure how much those types of medications were affecting somebody's ability to operate a vehicle.
They definitely can be, just like the ones that are taking it as prescribed that are on, say, 120 milligrams of morphine sulfate prescribed by their doctor and they're taking as prescribed. They are potentially impaired. And somebody brought up the idea of, so if they get 180 for the month, let's say, and it's a week after that prescription was filled and they only have 30 left, clearly there's a problem there. But the question is, when somebody gets those opioids prescribed for the first time, so they're opiate naive, so to speak, their brain, their central nervous system is not used to opioids. If they were to take, in that scenario, whatever it is, 110, I forget, or 90, whatever it is, pills, all at once like that, they would overdose and die, whereas somebody who's been on those medications as prescribed for, say, 3 years, and they take, say, 3 times the dose that was prescribed, they will certainly be impaired, but they're not going to overdose. So there is this issue of tolerance, and that does occur with the prescribed maintenance drugs as well. So in other words, Suboxone-type medicines and methadone maintenance medicines. So methadone you usually start 20 or 30 milligrams, but by the time I see patients, they're often prescribed 120 milligrams a day, so, which, by the way, is a lot of methadone. So it's hard to say based on a dose number, above 90 milligrams or whatever, which is, you'll see that around in some places of morphine equivalents. They are, at more risk of this or that. But it's different for the individual. So somebody that's on 90 milligrams that's never touched an opioid is absolutely at great risk of impairment, whereas somebody who's been prescribed 90 milligrams for a year and taken as prescribed is probably not as at risk, but certainly their coordination may be impaired. And so then how do you measure that without, so the fact of the matter is the same is true with alcohol, right? So the daily drinker, and I think one of the judges pointed that out as well, their blood alcohol level, if they're drinking every day to the point where they can tolerate a fifth of vodka and they're still talking, their tolerance, I'm not arguing that they should be driving, obviously they shouldn't be, but they can probably at least have a conversation and they're awake and alive, whereas I don't think I would be, and I don't think most of the people in this room would be. So this challenge of tolerance based on a numerical scale of a blood alcohol level or a breath alcohol level or a urine drug screen is very challenging because it doesn't necessarily correlate with neurological impairment. And in my opinion, neurological impairment would be the public safety issue. So if you have more tolerance and you're able to tolerate a higher dose of something, and so when you look in the blood for that substance and there's a lot of it, but that person has been using that substance for a long time, they may not be quite as impaired. So is there a way to develop new technology? I mean, now there are cars that they shake your seat if they notice that your eyes are diverting off the road or whatever, or if your car is going. So they could, I mean, this needs to be developed, obviously, but I think funding for the development of those types of products that will improve safety from a coordination perspective, more so than a drug monitoring perspective, will probably reduce further the risk of harming society or harming people that are in the way of this impaired driver or the driver themselves. The other thing that came up a couple times that I also want to point out, so Uber and Lyft, I think that should be like their marketing campaign. We can prevent or reduce the risks of impaired driving incidents. It's a phenomenal tool, and I do the same thing. I tell all my patients, get an Uber account, get a Lyft account. There's no reason why you shouldn't. I mean, there's a cost, of course, but there's a huge cost to a DUI. So when you weigh out what it costs to take those risks, maybe that could be an interesting program, is to offer other ways to get to where you're going so that you're not impaired. And education, by the way, I want to point out, not directly to your question, but a few people pointed that out. Number one, I think it was you, sir, that said that driver's education has gone by the wayside. I was flabbergasted to hear that. So they don't do it anymore? Is it basically they don't have it? I mean, that's just unbelievable to me. I think that's a critical point in the process of getting the education for safe driving, which includes not driving impaired. And I agree, by the way, the other thing about, at the point of arrest or the point of being pulled over when you're impaired is an opportunity to get somebody off the road and into a treatment. I mean, I just want to focus on that there's all the laws, and I'm not a lawyer, so I can't speak as well to those, but I can definitely speak to, if you can help get the people to my office or to my colleague's office, we can help improve public safety. But we're not getting them necessarily as a result of court mandate. And the providers that are getting them are not necessarily evidence-based programs. And I think that that's important for the legal side to research and make sure they're getting not necessarily the loudest person in the room who's saying send them to my program or making it easy enough for them to come to my program, but maybe the one that shows the best outcomes. Because in medical practice, we're moving towards outcome-based payment structures, trying to prove that you're doing a good job, that you're helping people get well in order to get paid. So that should maybe be considered here as well.
Well, thank you very much, Doctor. Appreciate your testimony, your time. Appreciate
Absolutely.
it. Thank you.
Thank you very much.
Our next testifier is Lieutenant Mark Pisano, Assistant Director of the Policy and Legislative Affairs Office of the Pennsylvania State Police. You may begin.
Yes. Good afternoon, Chairman Marsico, Petrarca, Taylor, and Keller, members of the House Judiciary and Transportation Committees. My name is Lieutenant Mark Pisano. I'm the Assistant Director of the Policy and Legislative Affairs Office for the Pennsylvania State Police. And I'm pleased to be sitting here today with Corporal Scott Davis, who's our Drug Recognition Expert Coordinator for the Pennsylvania State Police. And we are happy here to be talking about this important issue of drug driving in the Commonwealth of Pennsylvania. Drug driving is a national epidemic that we believe will continue to increase for years to come. In 2017, the Pennsylvania State Police was responsible for making nearly 20,000 driving under the influence arrests, which is a 2.1% increase over the previous year. Over 1/3 of those, actually close to 35%, or 7,131, were drug-related arrests. That figure represents an increase of about 33% from the previous year. According to the National Highway Traffic Safety Administration, a staggering 10,497 lives were lost to impaired drivers in 2016, and of those, 327 were fatalities recorded in Pennsylvania alone. The cost of impaired driving on society is equally staggering. It's estimated that impaired driving costs Americans about $132 billion each year, and that cost is felt by everyone in the form of higher insurance rates, property damage, medical costs, and of course, and probably most importantly, the tragic loss of loved ones. For the purposes of DUI enforcement, the definition of a drug is any substance which, taken into the human body, can impair the ability of a person to operate a vehicle safely. This definition not only covers substances listed in the Substance Act, the Controlled Substance Act, Act 64, but it also covers the over-the-counter medications and household items like gasoline or even keyboard cleaner that could be used as an inhalant. The state police has partnered with PennDOT in educational campaigns on this issue. We've been working with municipal police and organizations such as the PA DUI Association, the PA District Attorneys Association, to train our troopers and other officers in the detection of drivers impaired by drugs or alcohol. Training programs such as the Drug Evaluation and Classification Program, the Advanced Roadside Impairment Detection Enforcement, or ARIDE as you heard it referred to, standardized field sobriety testing, prosecuting the drug driver, and drug trends are all classes being offered across the Commonwealth. In 2017, we conducted 85 training sessions, which resulted in more than 2,000 police officers being better trained in the area of detecting impaired drivers. The Drug Evaluation and Classification Program is vital in combating drug-impaired driving. While many individuals and officers are familiar with the effects of alcohol impairment, drug impairment is much more complicated. The DECP is an international program overseen by the International Association of Chiefs of Police that trains officers to become drug recognition experts. This program, administered by the PA DUI Association and the Pennsylvania State Police, provides intensive training to officers and has set standards that will allow those trained officers to be recognized as experts as DREs. This is vital in the detection and successful prosecution of impaired drivers. Currently in Pennsylvania, there are 169 active DREs across the Commonwealth. 95 of those are in the Pennsylvania State Police, and 74 are municipal officers representing about 66 different agencies. In 2017, DREs conducted 1,694 drug influence evaluations across the Commonwealth. Drug influence evaluations are sometimes conducted when the arresting officer requires additional evidence of impairment in order to successfully prosecute a DUI case. The role of the DRE is vital in the DUI detection process, including cases in which a driver may be impaired by drugs. Recent case law has put additional limitations on drawing blood and, in turn, making it more important than ever to have an expert there to testify for prosecution in certain cases. Furthermore, a DRE can also be utilized to rule out drug use in certain cases. In fact, in 2017, 47 individuals were identified through the utilization of a DRE as suffering from a medical condition and were transported to a medical facility for treatment rather than the original suspect of a DUI charge. I would like to conclude by saying thank you for the opportunity to testify before the committee on this important subject. We appreciate your steadfast support of law enforcement and our efforts to keep Pennsylvania's highways safe. Corporal Davis and I will now be happy to answer any questions you may have.
Chairman Taylor.
And sir.
Lieutenant, I guess the DRE is the best we have in lieu of the electronic or any kind of technology to monitor their level of impairment on whichever drug, correct?
As far as any devices, hold on, let me get this over to Corporal Davis.
For the purpose of detection roadside, we really don't have technology as far as like a breath detection device. There are products out on the market that have not really qualified as being accurate at this point, but we don't have any other technology. The drug recognition experts look at people who are suspected of being driving impaired. We look at signs and symptoms that are exhibited in the body, and we need to have that for court purposes so that we can get that conviction. If post-Birchfield, the case law limiting our blood draws, if they refuse, the DRE is really the only avenue that we have to enter that into court.
And when do you step in there? When does that occur? So someone stopped on a highway, appears that they're either alcohol impaired or drug impaired. When does someone trained like you get into the mix?
Ultimately, the best case scenario is we're trying to get all officers in the state of Pennsylvania trained. The state police have an initiative. We're training all of our troopers by 2020 to be A-RIDE trained, which recognizes people under the influence of drugs. So they will do roadside tests, standardized field sobriety test. And then the final part of that test is they will give them a breath alcohol test, a preliminary breath test. If their level of impairment does not match that BAC, then we suspect drugs are probably the cause. They will contact a drug recognition expert at that time. We will respond either to the hospital, the police station, and do an evaluation. It's a 12-step evaluation where we look at many factors, pupil sizes, observation of the eyes, pulse, blood pressure, body temperature, how they perform on standardized tests. The DREs go through approximately 4 weeks of training, a very extensive training, in order
Did you
to
say 40 or 4?
4. It's 4 weeks, and as it was referenced earlier, it's a big expense for officers to be off the road for that amount of time. But they are truly recognized by the courts as experts in looking at people who are impaired and being able to get those convictions, and get them into the system.
Very good. Thanks.
Any other questions? No other questions? Well, good job, guys. Thanks for coming over. Appreciate it. So we do have testimony submitted by Pennsylvania AAA, Janet Tidwell, Manager of Public and Government Affairs. We're going to enter this testimony into the record, into the hearing record. So is Janet still here? Oh, do you want to just give her a few minutes? Sure. Why don't you come up and if you could just summarize your testimony, if you don't mind.
Thank you very much for the last-minute consideration. We certainly appreciate that. In the interest of time, I'd be happy to, you have the complete testimony. The issue of drug and drunk impaired driving is a complex one that impacts many public policy areas, as we've heard here today. I'm here to raise AAA's grave concern regarding the impact of drugs, both legal and illegal. One drug, of course, that's of interest to AAA that we're watching is the use of marijuana, and that's for several reasons. The significant increase in the proportion of fatal crashes involving recent use of marijuana, the lack of tools to determine impairment based on the presence of active THC, and a lack of understanding by the general public about the impairment capabilities of today's marijuana and the impact it has on driving ability. We know this as well as many of the other people here today, and we've been raising this issue across the state, in particular a drug driving policy summit that we held in Harrisburg a year ago. That forum brought together experts, more than 150 participants, legislators, law enforcement, medical experts, gathered to discuss the challenges that we're facing here in Pennsylvania. As part of that, we conducted an exclusive AAA poll in March of last year where we were able to determine 92% of those surveyed by AAA consider someone driving after using illegal drugs is a serious threat to their safety. and 72% of Pennsylvania drivers say that they are somewhat or very concerned about the dangers posed by others driving under the influence of marijuana, should it become legalized for recreational use. Surprisingly, the poll revealed that motorists have quickly grasped the dire threat that we have today to their safety posed by other drivers driving under the influence. This is especially significant when considering the number of years that it took to change social perceptions about the dangers posed by drunk driving. And nationally, the AAA Foundation for Traffic Safety released its 2017 Traffic Safety Culture Index report just last month, noting that more than half, about 55% of drivers believe that drivers using drugs pose a much bigger problem or somewhat bigger problem today than they did 3 years ago. Recognizing an important need, AAA has established a partnership with the National Highway Traffic Safety Administration and the International Association of Chiefs of Police, the two organizations responsible for the DRE program that we just heard about, to develop a pilot and launch an 8-hour courtroom training program for DREs and prosecutors. The goal of the training is to assist and develop DREs and prosecutors to more successfully adjudicate drivers charged with drugged driving. Again, it's taken many years to change the attitudes about drinking and driving, and we must now begin the same process, educating the public about drugged driving. As an advocate for the safety of motorists and all roadway users, AAA is troubled by the safety implications of individuals using drugs, both legal and illegal, behind the wheel. We, of course, continue to monitor this issue in Pennsylvania and across the country, and we are committed to educating drivers on the dangers of drugged driving. Thank you again for your consideration.
Well, thank you. I had a chance to review some of your testimony, so I thought it was important for you to highlight parts of your testimony, so we thank you. Any questions? Thanks again.
Thank you.
Sorry? Representative Corbin?
Thank you for your testimony. I'm asking this because I know AAA offers automobile insurance to its members. Will they be taking into account and changing the rates for those holders of medical marijuana cards?
That I can't speak to right now.
Okay. I'm just curious.
I don't know from the insurance perspective.
Yeah.
There's a lot that's being worked out from the insurance perspective.
Sure.
So many unknowns, and we're watching, of course, what's happening in other states: Colorado, Washington State, California.
Mm-hmm. Okay, thank you.
Thanks, Jana.
Thank you.
So just want to once again thank all the testifiers for being here. It's really important to hear your thoughts and your recommendations. Also want to thank the City of Philadelphia for once again for their hospitality, and everyone, the public, for being here as well. Thank you. This concludes the hearing.